Commonwealth.
Now, Mr. Bradley, at the time that you sent that text, July 5th, 2013, were you summoned to appear? Did you have notice that you were due to appear in a county grand jury other than Suffolk County?
Yes.
And was it your understanding that you were going to be asked questions related to the shooting of you on February 13, 2013 in that grand jury?
Yes.
And when you sent the text message regarding your question to your lawyer about whether withdrawal of the lawsuit would somehow cause you to be held on perjury, what did you mean by that?
Prior to that grand jury summons, I had filed a civil matter against Mr. Hernandez. As I previously stated to the court, my whole objection was to try to figure out how to move forward with civil litigations, but not get him charged criminally. So being that I had a sworn document already, a civil one that he shot me, I was trying to figure out how I could go to the grand jury and not have to tell him that he shot me because I didn't want him charged criminally. I wanted to sue him and deal with it a different way.
But were you under the understanding that having him charged criminally would in some way affect your settlement on a lawsuit?
Yes, and in addition to that.
Objection, Judge, for the
comment
about the settlement.
All right, ladies and gentlemen, you may consider that only insofar as it relates to Mr. Bradley's state of mind. That is, what he was thinking or concerned about. References to any lawsuit or settlement of a lawsuit are not relevant in any way to the issues in this case, and you're not to draw any conclusions or inferences from the fact that there was a reference to some resolution of that lawsuit, nor are you to speculate at all as to what that resolution might have been. It is not relevant to this case, and it is not evidence from which you may draw any inferences in this case. Mr. Hagan put a question.
Just regarding your state of mind, Mr. Bradley.
Objection, Judge, this has been asked and answered.
Let's hear the question.
Just regarding your state of mind, Mr. Bradley, other than not wanting him to be charged criminally, did you have any other concerns regarding testifying honestly in a grand jury?
Objection, Judge. This has been asked and answered.
Overruled.
Now, my issue was I would, in essence, perjure myself if I filed a civil settlement or matter saying that Mr. Hernandez shot me and then went to the grand jury and told him I don't know who shot me, which is what I was torn between because I didn't want him charged criminally, but I wanted my civil matter resolved. So that would have constituted perjury if I said one thing and if one sworn document and said something in another.
And did you at some point even contemplate or intend to lie in the Bristol County grand jury and say you didn't know who shot you?
Sustained. Jury will disregard that question.
And just to clarify, Mr. Bradley, on Exhibit 311, within, correct me if I'm wrong and I'm reading this correctly, the text about your concern about perjury, giving two inconsistent statements as you've described, was that sent on 7/5/2013 at 12:38 a.m.?
Yes, it was.
And your question about trying to get out of testifying in the grand jury, how much longer was that, how much later after that was that sent?
It appears to say 12:40, 2 minutes.
And Mr. Bradley, you asked a number of questions about the phone and your consent to search the phone, correct? You recall those questions?
Correct.
And in fact, Mr. Baez showed you, I'm not sure if this has been entered yet, Your Honor, but if not, I would ask that the consent form be entered as the next number exhibit.
I believe that form's been entered previously.
I thought we received that as an exhibit.
We have no objections.
David, where are the recent exhibits? Do you recall? All right. Apparently it was shown but not received as an exhibit. We will receive that.
Mr. Bradley, just to clarify time frame, you're placing on the screen what's been entered as exhibit number 312. That's the consent to search that was shown and referenced by Mr. Baez during cross-examination, right?
Correct.
And the date that this is signed is in September of 2014, is that right?
That is correct.
And in this document, you agree to relinquish full custody and control of the item and its contents. Tell me if I'm reading this correctly. I also acknowledge that I'm voluntarily relinquishing any expectation of privacy and cellular phone and its contents. You basically give the Boston Police the permission above to conduct a full forensic search of the phone as well. Is that correct?
That's correct.
And recover and download any and all digital data and files contained therein.
That is correct.
And Mr. Bradley, are you aware of how this phone was found and how it was that you came to give that consent? How and when it was found?
I can't remember the exact date, but I believe I know it was recovered by my daughter's mother.
And seeing the date on the form of September 10th, 2014, do you believe it was found around that date?
Yes, it was close to that date.
And once that phone was recovered, what was your state of mind about the recovery of the phone?
Objection, Judge Relevant.
Sustained.
Well, did you have any communications with your child's mother, Brooke Wilcox, regarding what you wanted done with that phone?
Objection, Judge.
Sustained.
Mr. Bradley, what did you want done with the phone when you found it?
Well, when the phone was found, I didn't have a problem with her turning it over.
Did you want her to turn it over to the police?
Objection, Judge. Leading.
No, you may answer that yes or no.
Yes,
And in fact, on jail calls at around that time, do you recall whether or not you were excited or not excited when she told you she found the phone?
Objection, Judge.
Sustained.
Did
Move to strike.
The jury will disregard that question.
shortly after the police, well, strike that, shortly after Ms. Wilcox advised you that she found the phone, did Boston Police Homicide Detectives come speak to you?
yes,
And did they have you sign the consent form that's been entered as Exhibit 312?
yes,
And prior to signing that consent form, did the detectives threaten you, coerce you, or do anything to cause you to execute that waiver?
no,
Did you voluntarily relinquish all rights to that cell phone and allow the police to download every single piece of data on it?
yes, I did.
Did you provide any restrictions of things you wouldn't let them download, didn't want them to download?
None whatsoever.
And in fact, Mr. Bradley, did you also, yes or no, assist the police in determining what the passcode was for that phone, if you remember?
I believe I tried to assist, yes.
And when you did that, Mr. Bradley, did you know that some communications between you and your attorney, Mr. Pickering, were included on the cell phone?
Yes, I did.
And just by way of timing, Mr. Bradley, because I believe Mr. Baez asked you a number of questions on cross-examination about timing, this was in September of 2014, correct?
Correct.
And when was it that you entered into your agreement, if you remember?
Sometime in 2013.
October 8th, 2013, does that sound correct?
October 18th, I believe, yes, correct.
And Mr. Baez asked you a number of questions about the text messages where you recall the text message questions that Mr. Baez asked you, correct?
Correct.
And I believe he asked you questions about the text messages where you referred to certain weaponry, certain types of guns and those things. You recall those questions Mr. Baez asked you?
Yes,
And then Mr. Baez also asked you whether or not your deal was deemed void after the Commonwealth received those text messages. You recall that?
yes, I do.
And in fact, is it fair to state that those text messages were not even uncovered until after September 2014, when you turned over your phone voluntarily?
That is correct.
And did you turn over your phone voluntarily knowing that you had the text messages between you and Mr. Hernandez?
Yes, I did.
Now, just a few questions, Mr. Bradley, about your cooperation agreement that was referenced repeatedly by Mr. Baez. First, regarding the timing of it, I believe Mr. Baez asked you questions about the proffer on October 8th, 2013. Do you recall those questions? Or do you recall being asked about that?
Yes, I do.
And I believe you testified that that was when you signed the agreement and then gave a tape recorded statement. Is that correct?
Yes, I gave a tape recorded statement on the 8th. Is that right? I believe that's correct.
But on the 8th, after you gave your statement, did you have a, as Mr. Bias kept referring to it, did you have a deal yet?
No.
Is it fair to state that you didn't have a
I
deal?
object to the leading. I've let it go on for a little bit, but
Please don't lead the witness.
When was it that you ultimately had the deal, so to speak?
On the 18th.
10 days later.
Correct.
Now, Mr. Bias asked a number of questions about the portion of exhibit number 301, specifically paragraph number 2, talking about the satisfaction of the district attorney that Mr. Bradley was not the individual who fired the weapon, and that upon satisfaction of the district attorney, that the Commonwealth agreed to apply for judicial immunity prior to you testifying before the grand jury. Is that correct?
That's correct.
Now, as far as the satisfaction of the district attorney, Mr. Bradley, is it fair to state, or what is your knowledge as to when the district attorney was satisfied allowing you to testify before the grand jury and be given immunity? What date?
On the 18th,
So 10 days later.
10 days after I came in proffer.
And just to clarify on judicial immunity, Mr. Bradley, Mr. Baez asked a number of questions suggesting to you that at any point if the Commonwealth or if the district attorney was dissatisfied with your answers or felt that you were not truthful, that your immunity could be revoked. Do you call those questions?
Repeat that, please.
Do you recall Mr. Baez suggesting that your deal of having judicial immunity could in some way be pulled back by the district attorney if they felt that if the district attorney felt you were not being honest and truthful? Do you recall those questions?
Yes, I do.
And in fact, Mr. Bradley, you're aware that immunity, once it's issued, it's by law not conditional.
Yes, I do. I understand that.
And in fact, you're immunized for any of your actions.
the judge calls for legal conclusion and to strike.
Your Honor, I request that judicial notice be taken and an instruction be given to the jury.
Yeah, I'll see you at sidebar. Put that back on if you would. Just zoom out a little bit.
What's your mouth?
All right, ladies and gentlemen, I want to give you two instructions, more explanations than anything else. There was questioning both on cross-examination and just a moment ago on redirect examination as to the terms of this so-called cooperation agreement or proffer agreement as it's been described, what has been put on the screen. And among the terms of that agreement were that Mr. Bradley would not be charged if he provided full and complete cooperation and truthful information to the satisfaction of the district attorney. And if the district attorney was satisfied, as is referenced here, that Mr. Bradley was not the shooter on July 16, then they would seek immunity for any testimony before a grand jury or trial jury. As to the terms of that agreement, you should understand that that agreement does not mean in any way that the district attorney is vouching for the truthfulness of the testimony of any witness, Mr. Bradley or anyone else, nor does it mean that the district attorney, by entering into this agreement or by seeking immunity, is in some way vouching for the credibility of this witness. The fact that the district attorney may have some views has absolutely no bearing on your function as the finders of fact, because ultimately you, as the jury in this case, are the sole finders of fact and the sole group to determine the truthfulness or the credibility of any and all witnesses, and not the district attorney or anyone else. So understand, the fact that the district attorney's office entered into some agreement with Mr. Bradley is not in any way any evidence as to the truthfulness or lack of truthfulness of any information provided thereafter. That's instruction number 1. Instruction number 2 relates to an explanation of immunity as it has been referenced. What you've seen on the screen, what has been referenced, is a so-called cooperation agreement, a promise by the Commonwealth to a witness in exchange for something that witness is giving, in this case, information of some sort or testimony. That's an agreement between a prosecuting officer and a witness, and nothing more. It is not binding necessarily on all the courts of the Commonwealth or on any parties other than the parties to that particular agreement. Immunity is different. Immunity involves an order issued by a court that has binding force throughout the Commonwealth. Under our law, a prosecuting officer, a district attorney or an attorney general, may seek, by filing a petition, that a court grant an order of immunity to someone, and thereafter, once granted, order that that someone, that witness or person, then provide testimony. And under the law, immunity means that the person providing that information, that is being compelled by order of court to testify, is then guaranteed that because they are forced to testify, they are given a promise by the law, by the court, that they shall not be prosecuted for any matter about which they testify in a compelled fashion, that is, under court order. So immunity is a grant of essentially transactional protection for anything about which they testify as a witness in court. The sole exception to immunity is that if a witness testifies falsely, that is, commits what's known as the crime of perjury, intentionally providing false evidence as to a material matter, then immunity does not protect against the crime of perjury, and an order of immunity would not prohibit a prosecution for the crime of perjury. That is the sole exception when a grant of immunity is given by a court of the Commonwealth. And understand that when the courts of the Commonwealth, most commonly this court, the Superior Court, issues an order of immunity, it applies to all state prosecuting officers in the Commonwealth, in Massachusetts. Does not apply to the federal government and does not apply to other states or prosecuting offices outside of the Commonwealth. It simply says that the Massachusetts law enforcement shall not prosecute, nor the Massachusetts courts punish someone who has testified as the result of a grant of immunity and prosecution for matters about which they have testified. So that's a little primer in the law. Mr. Hagan.
So, Mr. Bradley, just based upon your own state of mind and also His Honor's instructions, what is your understanding if you were to take the witness stand and testify that somebody else murdered Daniel D'Abreu and Safira Furtado, whether or not you could still be prosecuted for murder?
Objection, Your Honor.
Now overruled as to this witness's understanding.
Repeat it, please.
Even if you took the witness stand and testified under oath that somebody other than the defendant, Aaron Hernandez, shot and killed Daniel D'Abreu and Safira Furtado, could you be prosecuted for murder?
Absolutely.
You think you could?
Repeat it. If I took the stand and prosecuted that someone else other than Mr. Hernandez
Yes.
committed the murder,
Well, let me ask you another question, Mr. Bradley. What is your understanding of immunity? Is it once you're given it, you have it for the duration, or do you think it's conditional?
My understanding is that you have it unless you lie.
So unless you lie, then you can be prosecuted for what?
For perjury.
But that's it, perjury, correct?
Correct.
And as in your state of mind, and also, again, His Honor's instructions, just calling your attention to Mr. Baez's questions, I believe yesterday or perhaps this morning, about the fact that you admitted to getting the gun, and whether or not you were prosecuted for that, or whether or not the Commonwealth pulled its agreement. You recall those questions, Mr. Baez?
Yes, I do.
But were you compelled to testify about that in the grand jury pursuant to your immunity agreement? Did you testify about that?
Yes, I did.
So, Mr. Bradley, what is your understanding as to you having to satisfy the prosecution in order to get the benefit of immunity?
It's my understanding that it's not my job to satisfy anyone. It's my job to just state the facts.
So we're going to move on to some of the factual questions that Mr. Baez had asked you. He most recently asked you about the Forerunner and when the last time was that you saw it. What's your best memory as to, in relation to the early morning hours of July 16, 2012, when the last time you saw that Forerunner was?
My last memory of that Forerunner was Miss Singleton taking the Forerunner from the residence on 47 Newberry Street, and that was it.
And just to clarify, timing-wise, was it after that point that you had a conversation with the defendant that you previously testified to regarding what he had asked Tanya to do with the car? Was it after that?
No, the car was removed prior to me having a conversation with him about that.
Right. So the car was removed, and then you subsequently had a conversation with him about her doing something to the car.
Correct.
And what was that he asked her to do with the car? I told you he asked her to do with the car?
He wanted her to clean it and then hide it.
And then Mr. Baez asked you, or he actually read a portion of a transcript where you referenced the stadium incident with the car. And just to clarify for the jurors, what incident was that, and what's your recollection as to when that conversation took place?
I don't remember exactly, but I recall Mr. Hernandez saying that someone came to get the car. I believe it was the car dealer, and that he told him to leave, that he was upstairs. I guess they called him and told him they were downstairs to get the truck, and he told him to leave. And
Did he tell you why he did that?
he didn't want them to have the car.
Did he think they were somebody?
Yes, he thought it was the police.
So was this conversation...
Objection, Judge, calls for speculation and discussion.
All right, put a question.
Did he tell you what he thought, who he thought they were?
Yes,
Who did he say that he thought they were?
he told me he thought it was police coming to get the car.
And this conversation, was this after July 16, 2012?
I believe it may have been, yes.
Now, you're asked a number of questions by Mr. Baez where he showed you certain travel documents, and I believe the heading on the top was Lux Travel. You remember those questions and seeing those documents?
Yes, I do.
And I believe, Mr. Bradley, correct me if you're wrong, but you did authenticate, yes, that's your name on the travel documents, correct?
Yes, I did.
Did you make those travel arrangements?
No.
Were those tickets you purchased?
No, Mr. Hernandez called me and told me to give him my first name and my information so his flight lady could book the flights for us.
And his flight lady, do you know what company they booked flights through?
No, I don't.
But Lux Travel, is that a travel agency you've ever used, personally?
No, I never heard of him till today.
Now, you're asked a number of questions by Mr. Baez about the phones that you had, your phone records, and the fact that you had two phones. You recall those questions?
Yes, I do.
And I believe in response to one of Mr. Baez's questions, you said, I can tell you who had my phone and what the circumstances were in and around February 13, 2013. Do you recall giving that answer?
Yes, I do.
Explain what you meant.
The 726 number that he was indicated, well, 860726 number, was in Connecticut at the time.
Who had it?
I had left it with a friend of mine so he could proceed with my business while I was in Florida.
And the phone calls, purportedly, at least from what Mr. Baez showed you from the exhibit, I believe it was perhaps 294, the phone calls to Mr. Hernandez's phone on February 13, 2013, do you know what the nature of those calls were?
Yes, that was from my friend who had my phone in Connecticut.
And those phone calls, did those happen after you were shot? Or around the time you were shot?
Yes, I believe so.
And did you make those phone calls?
Absolutely not.
So when Mr. Baez asked you repeatedly if you had two phones in Florida, did you have two or did you have one in Florida?
At no point did I have two phones in Florida.
So the 860, and what was the other prefix?
I believe it had to be either oh, you mean
Which one was the one up in Connecticut?
860-726. I can't remember the other four digits.
The one that had 726 was the one in Connecticut.
Correct.
And I believe you were also asked some questions by Mr. Baez regarding your phone itself and whether or not it was lost. Do you know what happened to your phone in particular at Tootsie's?
No.
Do you know for a fact that you left it behind, or do you know whether or not somebody may have taken it?
I know for a fact that I left it behind, and I don't know after that point what happened.
Did anybody ever return the phone to you?
No, sir.
Now, Mr. Bradley, you're also asked some questions by Mr. Baez regarding your testimony. I believe it was in your October 8th, 2013 statement regarding the car ride from Massachusetts to Connecticut taking about 2.5 hours. You recall those questions?
Yes, I do.
I believe Mr. Baez read you a portion of your answer where he read back to you that you thought.
I object to this leading testimony.
Put the question, please.
What is your recollection of what you told detectives as far as how long the car ride took?
I don't recall exactly how long I said the car ride took.
And did you ever describe to detectives in October of 2013 whether or not you had gotten lost?
Yes, I said that I believe we may have gotten lost along the way.
In addition to getting lost, Mr. Bradley, did you also indicate to detectives at or around the same time describing how long it took as to whether or not you were always...
To the leading.
Rephrase.
Did you all, in addition to getting lost, did you also describe whether or not you were planning to go somewhere else other than Connecticut?
Continues to lead.
No, overruled.
Go ahead, sir, you can answer.
Yes, I indicated at one point I believe we were going to go to Plainville originally, which was his old residence.
Based upon the initial intention to go to Plainville, Mr. Bradley, did that change your route at all back to Connecticut?
Yes, that would have rerouted us.
Would you have gotten on different highways to go to Plainville? For those who may not know where Plainville is.
Yes.
Mr. Bradley, you were also asked a number of questions on cross-examination by Mr. Baez regarding whether you heard 6 shots or 5 shots. Do you recall those series of questions?
Yes, I do.
And I believe you indicated on cross-examination that when you testified before the grand jury, you said how many shots in the grand jury?
I recall saying 5 shots.
And I believe Mr. Baez called your attention to your initial statement on October 8th, 2013, where he read a portion to you that said about 6 shots or something to that effect. Do you recall that line?
Objection, Judge. That's not what the transcript reads.
Put the question.
What is your recollection as to what you said on October 8th?
Objection, Judge. I would ask that you use the actual transcript instead of trying to minimize it.
The witness may answer that question.
I don't know if it's exactly on the 8th, but I know at one point I said 5 or 6 shots.
And what, if any, confusion was there for you as to 5 or 6 shots?
Objection, Judge. If
Overruled.
there's a question about the statement, I would ask that he use the actual transcript instead of
Repeat the question, please, Mr. Hagan.
reading the false testimony before the jury.
Overruled.
What, if any, confusion was there between 5 or 6 shots initially for you, sir?
Well, I would guess that I just know that type of gun holds 6 shots. So
Did you hear any noises after the shots were fired?
Yes, I heard clicking noises.
And just based upon if you know, what noise does a gun make when it's empty, a revolver, and you continue to pull the trigger?
It makes a clicking noise when the gun's empty, when the chamber's empty.
But ultimately, Mr. Bradley, you've already testified to this. You testified in the grand jury to hearing 5 shots, correct?
Correct.
Did anybody prior to you testifying in the grand jury, whether it be police or prosecutors or anybody, suggest any significance whatsoever to 5 shots versus 6 shots?
No, sir.
Was there any conversation at all regarding 5 shots versus 6 shots from prosecutors or detectives prior to you going to the grand jury?
No, sir.
In your mind, was there any significance whatsoever to 5 shots or 6 shots before testifying in the grand jury? In your mind?
Well,
Objection.
Well, I mean, let me rephrase the question.
Rephrase.
I think it was a little confusing when I answered it. Did you think that it was more important for the case to say 5 shots rather than 6 shots when you testified in the grand jury?
Objection, Judge. Speculation.
I'll see you at sidebar.
Jury in October of 2013 to there being 5 shots fired from the gun. In your mind, was there any significance to there being 5 rather than 6 shots?
Objection.
No, over.
In your mind.
no.
And had anybody told you that there was any significance to that?
Asked and answered.
Sustained, I think that's recovered.
Now, Mr. Bradley, I just want to clarify a couple points regarding your shooting in Florida. Actually, while that's being looked for, Mr. Bradley, let me ask you some other questions. On cross-examination, you were shown what's now been entered as Exhibit 302. Is that correct, sir?
That is correct.
And you were also asked questions about whether or not you observed Mr. Hernandez ever have this picture taken. You recall that?
Yes, I do.
And I believe your answer at one point to one of Mr. Baez's questions on cross-examination was, I wasn't babysitting him. Did I write that down correctly?
That's accurate.
And calling your attention now to the very beginning of the night when, as you described to Mr. Baez in cross-examination, you went to the left side of the bar, he went to the right. Was there a period of time that you lost sight of Mr. Hernandez?
Yes, there was some period of time.
Sustained.
Did you,
Move to strike.
No, let's wrap it up.
Mr. Bradley, was there ever a point during the night when you first went into club where you lost sight of Mr. Hernandez?
Objection, Judge. Asked and answered.
Overruled.
Yes,
When was that?
when we first came down into the bar.
Do you know about how long it was that you lost sight of him?
I can't exact it. No, not exactly.
And in fact, Mr. Bradley, at some point, did I show this photograph to you some time ago?
I believe you may have.
Objection, Judge.
Sustained.
May we approach?
No, there's no need. Is there anything further?
Yes. When you were showing this photograph, Mr. Bradley, did you identify this as a photograph taken on July 16, 2012?
Objection.
See you at sidebar.
Mr. Bradley, you were asked a number of questions on cross-examination about the Florida shooting. You recall being asked a number of questions?
Yes,
And I just have on the screen what's been entered as exhibit number 310, showing the parking lot area. Do you recognize this as the area where you were, after you were shot, you were pushed out of the car in this area?
yes.
Can you just clarify for the ladies and gentlemen of the jury your best memory of when you were pushed out of the car, where you landed and where you went from there?
Well, I was pushed out of the car in the alley. I was still further down.
So you were further down in the alley?
Yes. I believe I remember that alley.
So placing on the screen what's been entered as exhibit 307. Does that alley look familiar?
Yes,
So you believe you were pushed out there, sir?
yes, right over in this area to where I rolled right to the fence. So the fence was like, I kind of rolled.
Can you using, that's a touch screen in front of you, Mr. Bradley, can you, using the touch screen, show what your best recollection is of where you were pushed out and where you rolled?
I believe, I mean, I know I was in this area, but I just remember making a roll to a fence, like rolled over and used the fence to pull myself up.
And when you rolled over to use the fence to pull yourself up, Policing Exhibit 309 on the screen, is that the area where you rolled over to pull yourself up on the fence?
Yes.
Now, regarding the blood-stained area that was shown to you in photographs by Mr. Baez, I have on the screen 310, you indicated you weren't sure necessarily if it was your blood, but do you recall ever being in this area after you were shot?
I know I was at, when the ambulance pulled up, I was at the end of felt like a parking lot or a roadway, like some type of alley. I just remembered it being, stumbling to where some pavement was, and the ambulance picking me up from there.
And do you recall whether or not you did go back and forth in the alleyway, as Mr. Baez asked you?
No, I don't recall ever going like back and forth in that.
Now, you're asked some questions by Mr. Baez regarding the jail calls. You recall those questions and the fact that you were on recording indicating that you didn't know anything about the incident. You recall those calls?
Yes, I
Or
do.
those questions?
Yes.
And why was it that you stated you didn't know anything about the incident on the calls?
Objection, Judge, this was covered in the rec.
Sustained.
Now, you asked a number of questions by Mr. Baez about city angels. And I believe at one point in response to Mr. Baez's question, you said that you wanted to explain. What did you mean by the fact that Mr. Hernandez had some type of issue with people who wore City of Angels clothing?
The specific group of gentlemen who he felt he was in conflict with or that were staring at him the majority of them had on City Angels attire. Just the clothes they were wearing.
And to your knowledge, Mr. Bradley, is City Angels, is that a clothing line, an attire?
Yes.
And is that available to buy publicly by anybody?
Yes.
And are you suggesting that anyone who wears City Angels clothing is associated with some group that had a problem with Mr. Hernandez? Are you suggesting that?
No, all people that wear City Angels don't have a problem with Mr. Hernandez. The particular group in conflict has City Angels.
Mr. Bradley, you asked a number of questions on cross-examination about seeing the people you thought were at Club Cure at Club Capri across the street shortly after. You recall those questions?
Yes, I do.
And I believe in one response to Mr. Baez's questions, you said, I believe it was them. They looked similar to the group. Do you recall saying that?
I recall saying,
I object. I had asked that you use the transcripts if you make certain allegations about what Mr. Bradley actually said.
No, I will deal with that. I'll hear you on that in just a moment, but we'll take up the rest of the testimony tomorrow. Ladies and gentlemen, we have yet another sidebar. There's no reason for you folks to sit through it.